So separation of powers is really simple. The national government is divided into three separate branches: the legislative branch, the executive branch, and the judicial branch. I put them in this order because that's the way the Constitution has them, and I'm not going to argue with the Constitution, except for that stupid 3/5 of a person thing. So the legislative branch comes first because it's supposed to be the most important branch. And Article 1 is the longest and most detailed of the 7 articles in the Constitution. The main job of the legislature is to make laws. The secondary job is to say, no, it's your fault. No, it's your fault. No, it's your fault. I'm going home. I have to campaign. Then we have the executive branch, and here the Constitution is a little less helpful. Article 2, Section 1 states, "The executive power shall be vested in a President of the United States of America." The executive branch is obviously more than just one guy or girl. The executive branch is in charge of executing the laws, which basically means carrying them out. So the President is like the CEO of the U.S., making sure that the government governs. Interestingly, the President's power as executive is found in the oath of office. "I do solemnly swear or affirm that I will faithfully execute the office of President of the United States, and will to the best of my ability preserve, protect, and defend the Constitution of the United States." Wait, Stan, I just gave the presidential oath of office, so I'm president now, right? Totally. Oh, elections. Yeah. We didn't have those. Last, and in the eyes of many people, least, is the judicial branch. The job of the judiciary, also sometimes called the courts, which I'm going to call the courts because judiciary is really hard to say, is to interpret the law, to explain what it means. Article 3, which describes the courts, is even shorter than Article 2. It has only 3 sections instead of 4, and the courts today don't really look like this description. Here's the first sentence of Article 3, Section 1. "The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish." At least the framers realized that the entire United States would probably need more than one court. But notice right there in the sentence that Congress has the power to create all other courts. And this leads us nicely into the second important concept of American government: checks and balances. Yeah, that was a segue right into it. It was a nice job by me. I'm going to need a little help explaining checks and balances, so let's do that part in the clone zone. Checks and balances is a confusing term because it implies 2 things, but really it would be better to think of them as checks that balance, although that might be confusing to people who actually try to balance their checkbooks. Anyway, the point here is that each of the branches has the power to limit or check the other 2, and this creates a balance between the 3 separate powers. In the same way that the Constitution lays out the legislature in the greatest detail, it also gives the legislature the greatest number of checks on the other branches. Legislative clone? So the framers of the Constitution were really concerned about the president becoming a tyrannical figure a la King George III. That guy was a jerk. So the Constitution gives the legislature a lot of power over the executive. The House of Representatives can impeach the president. Then the Senate can remove the president from office, but only if 2/3 of the senators vote for impeachment. The Senate can also check the president's appointment of judges and officials by rejecting them. This is known as advice and consent. Either branch of Congress can investigate executive activities and officers. If the president vetoes a law, Congress, with a 2/3 vote in both houses, can override the veto. Congress can also refuse to pass laws that the executive wants, and probably most important, they can refuse to appropriate funds for executive programs. You might think that since the judiciary is the 3rd and presumably least important branch, Congress would have fewer checks on it, but that would be wrong. Here are the ways that the legislative branch can limit the judicial branch. Congress can impeach and remove judges as it can do with the president. Congress can be a bunch of jerks sometimes. That's me. The Senate can reject judicial nominees, which is a check on judges before they even get there. Congress can change the federal court system by adding or taking away courts like it says in Article 3. And it can change the jurisdiction of federal courts. Congress can pass new laws that override Supreme Court decisions as long as the decisions aren't based on the Constitution. Don't want to do that. No. And as a very last super drastic resort, Congress can propose amendments to the Constitution as it did with the 13th, 14th, and 15th Amendments, overruling the Dred Scott decision. Wow, legislative clone. It looks like the framers were so scared about an all-powerful super president that they gave Congress most of the power. Executive clone? You know what? I'll be executive clone since I'm basically president of the clones. The executive branch can check the legislature in the following ways. The president can veto Congress's laws so that they don't go into effect. The president can call Congress into special session, but he can't make them pass new laws. The executive branch carries out the laws and may do so in ways that are contrary to what Congress wanted. Although this rarely happens, the vice president is given the power to break ties in the Senate, which is one of his only real powers other than embarrassing the president. The president nominates Supreme Court justices, and this can change the way the court works. He also nominates federal court judges, and this shapes the entire court system. The president can pardon people convicted by the courts, which cancels out their judgments. The president can also, in his capacity to carry out the laws, refuse to carry out court decisions. So you can see that even with the number of checks that it has, the executive branch is weaker than the legislature. But not as weak as the judiciary branch. Many political scientists consider the judiciary the weakest branch because without legislative and executive action, it doesn't have a whole lot to do. Being the weakest branch, the judiciary also has the fewest checks on the other two branches. Here's what it can do. The judiciary checks the legislature by declaring its laws unconstitutional. The Chief Justice presides over impeachment trials, and sometimes he gets to wear a special robe when this happens. Perk of the job. It's a perk of the job. It's really nice. And the judiciary checks the executive branch by declaring executive acts unconstitutional. A really good example of this was Youngstown Sheet and Tube Company versus Sawyer. Super important case. Look it up. Look it up. The court also issues warrants in federal crime cases, and again presides over impeachment trials in the Senate. But the big check that the courts have is in validating laws and executive actions. We'll talk about how courts actually do this and where they got this power in a later episode. No, I'll talk about it in a later episode. Now, okay? Let's go back to the regular desk. You're out of order! Thanks, clones. Now, some of you are probably saying, Craig, this is very helpful information, but why do we have checks and balances in the first place? To you, I say, stop talking to your computers. That's weird. I also say, let's go to the thought bubble. So the framers of the Constitution were terrified of a tyrannical central government that would destroy people's rights like they felt the British had. The powers of the national government are separated, and each branch is able to check the others because this makes it more difficult for the government to act in ways that harm the rights and interests of the citizens. One of the best explanations of this comes from, you guessed it, the Federalist Papers. In this case, Federalist 51, which was written by James Madison, who also wrote a lot of the Constitution and became president. So he kind of knows what he's talking about, and really it's a shame that he's not on our money, because then Americans would pay him more attention. They would also pay him. Literally. In Federalist 51, the title of which also contains the phrase checks and balances, Madison wrote, "But the great security against a gradual concentration of the several powers in the same department consists in giving to those who administer each department the necessary constitutional means and personal motives to resist encroachments of the others. It may be a reflection on human nature that such devices should be necessary to control the abuses of government. But what is government itself but the greatest of all reflections on human nature?" That's right, he wrote with an accent. Don't know how that's possible. Thanks, Thought Bubble. Madison was talking about checks and balances. I'll leave it up to you to decide if human nature requires that we build safeguards into our government to protect us from our leaders. But Madison thought so. And I think so too. But this isn't about me. This is about government. And it's helpful to remember that when people tell you that the framers of the Constitution were infallible, James Madison actually thought that they were outfallible.
Have you ever wondered who has the authority to make laws or punish people who break them? When we think of power in the United States, we usually think of the president, but he does not act alone. In fact, he is only one piece of the power puzzle, and for very good reason. When the American Revolution ended in 1783, the United States government was in a state of change. The Founding Fathers knew that they did not want to establish another country that was ruled by a king. So the discussions were centered on having a strong and fair national government that protected individual freedoms and did not abuse its power. When the new Constitution was adopted in 1787, the structure of the infant government of the United States called for 3 separate branches, each with their own powers, and a system of checks and balances. This would ensure that no one branch would ever become too powerful, because the other branches would always be able to check the power of the other two. These branches work together to run the country and set guidelines for us all to live by. The legislative branch is described in Article 1 of the U.S. Constitution. Many people feel that the Founding Fathers put this branch in the document first because they thought it was the most important. The legislative branch is comprised of 100 U.S. senators and 435 members in the U.S. House of Representatives. This is better known as the U.S. Congress. Making laws is a primary function of the legislative branch, but it is also responsible for approving federal judges and justices, passing the national budget, and declaring war. Each state gets 2 senators and some number of representatives depending on how many people live in that state. The executive branch is described in Article 2 of the Constitution. The leaders of this branch of government are the president and vice president, who are responsible for enforcing the laws that Congress sets forth. The president works closely with a group of advisors known as the cabinet. These appointed helpers assist the president in making important decisions within their area of expertise, such as defense, the Treasury, and Homeland Security. The executive branch also appoints government officials, commands the armed forces, and meets with leaders of other nations. All that combined is a lot of work for a lot of people. In fact, the executive branch employs over 4 million people to get everything done. The third branch of the U.S. government is the judicial branch and is detailed in Article 3. This branch is comprised of all the courts in the land, from the federal district courts to the U.S. Supreme Court. These courts interpret our nation's laws and punish those who break them. The highest court, the Supreme Court, settles disputes among states, hears appeals from state and federal courts, and determines if federal laws are constitutional. There are 9 justices on the Supreme Court, and unlike any other job in our government, Supreme Court justices are appointed for life, or for as long as they want to stay. Our democracy depends on an informed citizenry, so it is our duty to know how it works and what authority each branch of government has over its citizens. Besides voting, chances are that sometime in your life you will be called upon to participate in your government, whether it is to serve on a jury, testify in court, or petition your congressperson to pass or defeat an idea for a law. By knowing the branches, who runs them, and how they work together, you can be involved, informed, and intelligent.
For most jobs, it's understood that you can be fired, whether for crime, incompetence, or just poor performance. But what if your job happens to be the most powerful position in the country, or the world? That's where impeachment comes in. Impeachment isn't the same as actually removing someone from office. Like an indictment in criminal court, it's only the formal accusation that launches a trial, which could end in conviction or acquittal. Originating in the United Kingdom, impeachment allowed Parliament to vote for removing a government official from office, even without the King's consent. Although this was an important check on royal power, the King couldn't be impeached, because the monarch was considered the source of all government power. But for the founders of the American Republic, there was no higher authority beyond the people themselves. And so, impeachment was adopted in the United States as a power of Congress applying to any civil officers, up to and including the president. Although demands for impeachment can come from any members of the public, only the House of Representatives has the power to actually initiate the process. It begins by referring the matter to a committee, usually the House Committee on Rules and the House Committee on the Judiciary. These committees review the accusations, examine the evidence, and issue a recommendation. If they find sufficient grounds to proceed, the House holds a separate vote on each of the specific charges, known as articles of impeachment. If one or more passes by a simple majority, the official is impeached, and the stage is set for trial. The actual trial that follows impeachment is held in the Senate. Selected members of the House, known as managers, act as the prosecution, while the impeached official and their lawyers present their defense. The Senate acts as both judge and jury, conducting the trial and deliberating after hearing all the arguments. If it's the president or vice president being impeached, the Chief Justice of the Supreme Court presides. A conviction requires a supermajority of 2/3 and results in automatic removal from power. Depending on the original charges, it can also disqualify them from holding office in the future and open them to standard criminal prosecution. So what exactly can get someone impeached? That's a bit more complicated. Unlike in the United Kingdom, impeachment in the U.S. pits an elected legislature against other democratically elected members of government. Therefore, to prevent the process from being used as a political weapon, the Constitution specifies that an official can only be impeached for treason, bribery, or other high crimes and misdemeanors. That still leaves a lot of room for interpretation, not to mention politics, and many impeachment trials have split along partisan lines. But the process is generally understood to be reserved for serious abuses of power. The first official to be impeached was Tennessee Senator William Blount in 1797 for conspiring with Britain to seize the Spanish colony of Louisiana. Since then, the House has launched impeachment investigations about 60 times, but only 19 have led to actual impeachment proceedings. The 8 cases that ended in a conviction and removal from office were all federal judges, and impeachment of a sitting president is even more rare. Andrew Johnson was impeached in 1868 for attempting to replace Secretary of War Edwin Stanton without consulting the Senate. Over a century later, Bill Clinton was impeached for making false statements under oath during a sexual harassment trial. Both were ultimately acquitted when the Senate's votes to convict fell short of the required two-thirds majority. And contrary to popular belief, Richard Nixon was never actually impeached for the Watergate scandal. He resigned before it could happen, knowing he would almost certainly be convicted. Theoretically, the U.S. government is already designed to prevent abuses of power, limiting different branches through a system of checks and balances, term limits, and free elections. But impeachment can be seen as an emergency brake for when these safeguards fail.
I would describe the rule of law as fairness. It is a set of rules that everyone needs to abide by.
We can't have peaceful interactions with one another without the rule of law.
Our social compact is based on the idea that we are each and every one of us accountable to the law.
Your right to swing your fist stops just short of my nose. And that's what the rule of law is meant to do, is to find that boundary between expression, freedom, liberty, and everything we want to do, and when we hurt others.
For example, this morning I went to buy a breakfast sandwich, and everything that I did to get that sandwich was related to the rule of law in some way, in the sense that I was able to cross the street safely because I knew that the people driving their cars were going to stop at the stoplight. And I had trust that they were going to do that because there would be consequences under our law for that.
I can get up in the morning and know that the dollar will be accepted down the street at the grocery store. I can go to the post service and expect that I can retrieve my mail and that someone won't take it, or that someone won't view it without my permission.
I then go and buy the breakfast sandwich. I know that the company I'm buying the breakfast sandwich from has to follow the rule of law and with regard to food regulations, so I know that the food I eat is going to be safe. The company similarly can't overcharge me because there's going to be penalties for that.
It affects our quality of life in that we're able to sleep at night knowing that tomorrow morning we'll wake up, the stock market will be working, the speed limits will be enforced, the laws will be applied to each and every one of us.
One of the great things about the rule of law is the protection of minority rights. Our Constitution has embedded within it a counter-majoritarian principle. What the Founding Fathers said was to protect us against the tyranny of the majority.
The most important thing that I felt from taking the oath was to make sure that I applied the rule of law in a fair manner to everyone.
And what that means is that 51% of the people or 90% of the people can't deprive the minority of certain inalienable rights. The right to worship, the right to speak, the freedom of the press, the right to keep and bear arms, the right to be free from unreasonable searches and seizures.
No matter what their background, no matter where they came from, no matter what they look like. And that's what I try to do every day, is to apply the law fairly and evenly to every party that's before me.
We are bound to follow the law. The law is the statutes, the law that is written by people who are elected by the people. And we have to comply with that law. We have to follow the Constitution.
New citizens swear an oath, not to the flag or to the president or to America, but to the Constitution, to our supreme law of the land.
The rule of law means that everybody understands what the law is, and everybody also understands that they will be held to that law, and that there's no way of getting out of that, including the government.
Rule of law means that the laws are public. People know what they're expected to do, and you can rightfully hold them to that knowledge. Now, I'm not saying you could go out in the street and give a quiz about the U.S. Code to every person who's walking by, but the public nature of the law is critical. And the public nature of the judicial process is critical.
After reading a lot about Greek history, Roman Republic, Roman Empire, all the way forward up to the present day, it was interesting to see what made civilizations thrive and what made civilizations fail. And the only civilizations that thrived were civilizations that emphasized the rule of law.
The rule of law matters in all kinds of different ways. It's the foundation of what gives people the confidence to be able to speak their minds, for instance, knowing what the rules are in advance and they won't be punished by the government for what they say. Law really matters especially for economic development, for people to be secure in their property rights, know that their contracts are going to be enforced. And what we see when we look around the world today is that countries that have the rule of law tend to be richer and freer than countries that don't.
The constitutional principle of the rule of law means that we live under known and settled laws that were established in a system that is open for all to see. Like many constitutional principles, many take this idea for granted. We know that our laws are stable and that the rules of the game cannot just suddenly change. As John Adams said in 1776, the true idea of a republic is an empire of laws and not of men. Rules cannot be discarded or laws enacted on one person's whim unless established legal processes are followed.
One of the things that's most interesting about the rule of law is that has emerged in history. It is primarily a protection for the ordinary person. The rich and powerful have always had the ability, in some sense, to be able to manipulate the government for their own ends or find the loopholes in the law to protect themselves and that sort of thing. It's the common person, the person who doesn't hire the lobbyist, who doesn't have the ability to influence the government, that benefits most when the government protects the rule of law.
A look back at the way the Constitution was framed and ratified shows how committed Americans were to the rule of law. After flaws in the Articles of Confederation were identified, 12 of the 13 states sent duly appointed delegates to a meeting in Philadelphia to revise the Articles. When that convention, now called the Constitutional Convention, completed the document, the Constitution then had to be ratified by the states. State ratification took place in conventions, where the people elected delegates to represent them. The debate was intense, but never did people resort to violence to force their views on others. The Constitution and the Bill of Rights themselves provide some ways to ensure the rule of law is followed. The Constitution forbids bills of attainder, or laws passed to single out one person. It also bans ex post facto laws, which means the government cannot suddenly declare an action illegal and then punish people who did it in the past. All criminal trials will be tried by a jury. The police cannot search you or your property without getting a warrant from a judge by showing probable cause. People accused of crimes have many rights to due process. The right to know what they are being charged with, to consult with a lawyer, to confront their accusers. call witnesses in their own defense, and have their trial take place in a speedy manner in the location where the alleged crime occurred. A government cannot try a defendant over and over until it gets a guilty verdict. Excessive fines and cruel and unusual punishments are also forbidden. The most serious crimes require a grand jury to bring charges, and the crime of treason can only be proven by the testimony of two witnesses to the same overt act or on confession in open court.
Why do we afford certain protections to defendants in criminal cases? Why do we afford certain protections for freedom of speech and freedom of press? Why are there restrictions on the ability of the government to invade our private domains? All of these things have to do with the rule of law. All of these things have to do with living in a rights-oriented republic. All of these things have to do with due process of law.
Fundamental safeguards on freedom can only be suspended in specific cases. People accused of crimes tend to be disliked and even despised. A check on the power of the majority, which may want to set aside protections for due process in the name of revenge, is one purpose of the many safeguards for individual rights in the Constitution.
The need to make sure that the guilty are punished, the need to make sure that injured people get compensation in a timely and in a fair way and are not frustrated by a legal system that interferes with their rights or becomes too expensive or inaccessible. That's an important component of the rule of law, and I think it's important for us to recognize that unless we are responsive to the needs of the people and actually vindicating their rights, people will feel these frustrations in these outlets.
And, like all constitutional principles, the rule of law depends less on its being written down somewhere in a legal document and more on citizens' commitment to it.
Open crime, corruption in government, robbery, peaceful citizens' lives in danger, all stemming from a lack of respect for law. Is that what you want? Why, no. So we're all a lot better off respecting the law.
Having a people that respected the rule of law for Madison would have been absolutely essential to having a defensible and secure republic.
When laws are unjust, it means finding peaceful ways to persuade fellow citizens to repeal and replace them. A commitment to the rule of law means a belief in the duly established systems and processes, even if outcomes aren't what some expect. It means we may have to set aside our personal desires for revenge if we believe a guilty person has been set free. The people, through their elected representatives, always have the right to enact new laws if they believe changes are necessary. And when a government is repeatedly unjust, it may mean the right and duty to alter or abolish it. How transparent is our system of lawmaking? Our commitment to the rule of law sometimes raises questions. Should the U.S. enforce only those laws enacted by the people through their representatives? Does the U.S. have to enforce UN resolutions? International laws? Which laws exactly does the executive branch have the power to enforce? Does the president have to enforce all laws passed by Congress, even if he thinks they are unconstitutional? Can states nullify federal laws they conclude are unconstitutional? Will we live under the rule of law or the law of rulers?
The idea is that there is a law or a set of laws that are outside and above the government, that it constrains what the government is allowed to do to you. And so looking at the common law, looking at natural rights, and finally looking at the idea of a social contract theory, that the Constitution, again, is above and constrains the political leaders. Those three bases all reinforce the idea of the rule of law. The idea that there are laws given by history, given by nature, given by the Constitution that constrain what our political leaders are allowed to do to us.
In general, courts have three basic functions, only one of which you probably learned about in your history class. The first thing that courts do is settle disputes. In pre-modern history, which is way easier to understand than postmodern history, kings performed this function, but as states got bigger and more powerful, it became much easier to have specialized officials decide important issues, like who owned the fox you caught on someone else's land, or what does the fox say, which was disputed a lot back then. The second thing that courts do is probably the one you heard about in school, or on television, or perhaps while studying for the standardized test, and that's interpret the laws. This becomes increasingly important when you actually try to read laws, or when you realize that legislators are often not as careful as they might be when writing laws in the first place. Take a look at the Affordable Care Act. There are a few famous careless errors in that. Finally, courts create expectations for future actions. This is very important if you want to do business with someone. If you know that you'll be punished for cheating a potential business client, you're less likely to do it. Still, you might, because there are a lot of jerks out there who would. Are you one of them? Don't be. At the same time, if you know that people will be punished for cheating you, you're more likely to do business. And it's courts that create the expectation that business will be conducted fairly. Interpreting the laws can help this too, since the interpretations are public and they set expectations that everyone can understand and know what the law means and how it applies, and then world peace. No more law breaking ever. The first thing to remember about courts in the US is that most legal action, if it occurs in court at all, occurs in state court. And if it occurs at night, it occurs in night court. Because this is mainly a series about federal government and not Indiana government or sitcoms about court in New York, I'm going to focus mainly on the federal court system, which has four main characteristics. One, the federal court system is separate from the other branches of government. The executive could do the job, just like kings used to, but we have separation of powers, so we don't have to be at the mercy of kings. Have you seen Game of Thrones? Two, the federal courts are hierarchical, with the Supreme Court at the top and turtles all the way down. No, not turtles, sorry. I meant lower courts. What this means is that when a lower court makes a decision, it can be appealed to a higher court that can either affirm or overturn the lower court's decision. The third feature of federal courts is that they're able to perform judicial review over laws passed by Congress and state legislatures, and over executive actions. And the fourth aspect of federal court system is that you should know that the federal judges are appointed for life, and their salaries can't be reduced. This is to preserve their independence from politics. Sounds like a pretty sweet deal. Remember when I told you that the legislature makes the laws? Well, that was true, but it's also not the whole story. Legislatures, both state and national, make laws, and these written laws are called statutes. In continental Europe, those are pretty much all the laws they have. Statutes. Statutes everywhere. And statues. That place is filled with art. They had the Renaissance there, you know? But in the US and England, which is where we got the idea, we have something called common law, which consists of the past decisions of courts that influence future legal decisions. The key to common law is the idea that a prior court decision sets a precedent that constrains future courts. Basically, if one court makes a decision, all other courts in the same jurisdiction have to apply that decision, whether they like it or not. The collection of those decisions by judges becomes the common law. I don't have to have a reason to punch the eagle. I should probably point out what courts actually do and explain that there are two different types of courts that can make civil law. What differentiates the two types of courts is their jurisdiction, which basically means the set of cases that they're authorized to decide. Trial courts are also called courts of original jurisdiction. These are the ones you see on TV, and they actually do two things. First, they hear evidence and determine what actually happened when there is a dispute. This is called deciding the facts of the case. Not everything that happened or that may be important qualifies as a fact in a court case. Those are determined by the rules of evidence, which are complicated and would really slow down an episode of Law and Order. After the trial court hears the facts of the case, it decides the outcome by applying the relevant law. What law they apply will depend on statutes, and in some cases, what other courts have said in similar situations. In other words, the common law. You might have noticed that I've been referring to courts, not judges or juries, because not all trials have juries. Bench trials have only a judge who determines the facts in the law. Besides, who decides what in a court case isn't really that important. More than 90% of cases never go to court, by the way. They just get settled by lawyers out of court. But say you actually go to court and you lose. Naturally, you'd be upset, especially if you're a sore loser, like me. Shut up. You have a choice. You can give up and go back to your normal loser life, or you can appeal the trial court decision to a higher court, an appeals court that has, you guessed it, appellate jurisdiction. Did you actually guess that? That'd be amazing. Appeals courts don't hear facts. Who wants those? They just decide questions of law, so you don't have to bring witnesses or present evidence, just arguments. In most cases, if you want to bring a successful appeal, you need to show that there was something wrong with the procedure of your trial. Maybe the judge allowed the jury to hear evidence they shouldn't have heard. Maybe one of the jurors was a cyborg. Here's the way that these courts connect to what I was saying before about common and statutory law. Most common law is made by appeals courts, and because appeals courts have larger jurisdiction than trial courts, appeals decisions are much more important than trial court decisions. So now I'm going to talk about the three types of law, and it's going to get confusing. We should probably go to the thought bubble for some nice, compelling, intriguing animations. The two main types of law are basically the Bruce Banner of law. They're the criminal law and civil law, but they can sometimes morph into the incredible Hulk of laws, public law. Public law smash abuse of government authority. If you watch TV or movies or read John Grisham novels, you're probably familiar with criminal law. Criminal laws are almost always statutes written by legislatures, which means that there's an actual law for you to break. In most states, the criminal laws are called the penal codes. In a criminal dispute, and it's a dispute because the government says you broke the law and you will say you didn't, the government is called the prosecution, and the person accused of committing the crime is called the defendant. Almost all criminal cases happen at the state level, and for this reason, it's hard to know exactly what is or is not a crime in each state, although murder is a crime everywhere. There are also some federal crimes like tax evasion, mail fraud, and racketeering. If you're suing someone or being sued, you're in the realm of civil law. Civil cases arise from disputes between individuals, or between individuals and the government. When one party, the plaintiff, claims that the other party, the defendant, has caused an injury that can be fixed or remedied. If the plaintiff proves his or her case, the defendant must pay damages. If you lose a civil case, you don't go to prison or jail in most circumstances, but you may end up losing lots of money, and that sucks. I love money. Cases about contracts, property, and personal injuries, also called torts, are examples of civil law. So under certain circumstances, a civil or criminal case can become public law. This happens when either the defendant or plaintiff can show that the powers of government or the rights of citizens under the Constitution or a federal law is involved in the case. Also, if the law gets exposed to gamma rays. Law smash! For example, in a criminal case where the defendant claims that the civil rights were violated by the police, the decision can become public law. Thanks, Thought Bubble. So those are the basics of the court system in the US, and you can see that there's a lot to keep straight. There are types of courts, basically trial courts and appeals courts on both the state and federal level. And there are types of laws, basically statutory and common laws. The fact that we have both state and federal statutory law is an example of federalism in action. The US, unlike most other nations, has both statutory and common law, but most of the time when we're talking about federal laws, we're in the realm of statutes, or maybe the Constitution. When you study American government, most of the cases you read about are examples of appeals and of public law. How this all works in practice is even more complicated, and the adaptability of the American legal fabric allows statutes to stretch to fit the growing and changing American society. Okay, I think the only way we're going to possibly be able to compete with Schoolhouse Rock is to jump right into the thought bubble with our own cartoon, and to stop talking about Schoolhouse Rock. So let's start at the very beginning, which in this case is a congressman or a senator introducing a bill. The real beginning is when he or she has an idea for a law, and even this might come from an interest group, the executive branch, or even the constituents. But the formal process begins with the legislator introducing the bill. After its introduction, the bill is referred to a committee. Although most bills can start in either house, except for revenue bills, which must start in the House, let's imagine that our bill starts in the Senate because it's easier. Congress has the power to make rules concerning the armed forces, so let's say this is a bill about naming helicopters. Anywho, this bill would be referred to the Senate Armed Services Committee, which would then write up the bill in formal legal language, or markup, and vote on it. If the markup wins a majority in the committee, it moves to the floor of the full Senate for consideration. The Senate decides the rules for debate, how long the debate will go on, and whether or not there will be amendments. An open rule allows for amendments, and a closed rule does not. Open rules make it much less likely for bills to pass because opponents of the bill can add clauses that will make it hard for the bill's proponents to vote for. If opponents of our helicopter name bill were to add a clause repealing the Affordable Care Act or something, some supporters of the bill probably wouldn't vote for it. If a bill wins the majority of votes in the Senate, it moves on to the House. Thanks, Thought Bubble. We're going to have to go the rest of the way without fancy animation. But I could sing it. I'm not going to sing it. I'm not going to use a funny voice. The Senate version of the bill is sent to the House. The House has an extra step in that all bills, before they go out to the floor of the House, must go to the Rules Committee, which reports it out to the House. If a bill receives the majority of votes in the House, 238 or more to be exact, it passes. Yay! Now, this is important. The exact same bill has to pass both houses before it can go to the president. This almost never happens, though. Usually the second house to get the bill will want to make some changes to it, and if this happens, it will go to a conference committee, which is made up of members of both houses. The conference committee attempts to reconcile both versions of the bill and come up with a new version, sometimes called a compromise bill. Okay, so if the conference committee reaches a compromise, it then sends the bill back to both houses for a new vote. If it passes, then it's sent to the president. And then the president signs the bill, boom, done. That's the only option. Oh, no, there's two other options, actually. Option 2 is for him to veto the bill, and we've gone through all of this for nothing. The third option is only available at the end of a congressional term. If the president neither signs nor vetoes a bill, and then in the next 10 days Congress goes out of session, the bill does not become a law. This is called a pocket veto, and is only used when the president doesn't want a law to pass, but for political reasons doesn't want to veto it either. Congress can avoid this altogether by passing bills and giving them to the president before that 10-day period. If the president neither signs nor vetoes a law, and Congress remains in session for more than 10 days, the bill becomes a law, without the president's signature. So that's the basic process, but there is one wrinkle, or if you want to be all Madisonian about it, it, check on the president's power. If Congress really wanted a bill and the president has vetoed it, they can override the veto if it gets a 2/3 majority in both houses on a second vote. Then the bill becomes a law over the president's signature. Oh, snap! This is really rare, but it does happen once in a great while. The Taft-Hartley Act of 1953 passed over Truman's veto. I like to call it the Tartley Act. Shorten it. It's a portmanteau. It doesn't happen that often because if the president knows that 2/3 of the congressmen supported the bill, he won't veto it. And if Congress knows that they don't have 2/3 support, they won't try to override the veto. Nobody wants to try something and fail in public, right? Except for me, obviously, if you look at my other YouTube channel, Wheezy Waiter. So there you have it, how a bill becomes a law. I'll admit the process is a little cumbersome, but it's designed that way so that we don't get a lot of stupid or dangerous laws. Still, this doesn't quite explain why so few laws get passed. Bills have a very high mortality rate, and it's way more common for a bill not to become a law than to become one. The main reason is that there are so many places where a bill can die. The first place that a bill can die is at the murderous hands of the Speaker or Majority Leader who refuses to refer it to committee. Then the committee can kill the bill by not voting for it at all. And if they do vote and it doesn't get a majority, then the bill doesn't go to the floor, and it's dead. In the Senate, the murderous leadership can kill a bill by refusing to schedule a vote on it, and any senator can filibuster the bill, which is when he or she threatens to keep debating until the bill is tabled. It's a bit more complex than that, but the filibuster rules have changed recently, so hopefully we won't have as many filibuster threats in the future. The House doesn't have a filibuster, but it does have a rules committee that can kill a bill by not creating a rule for debate. The entire House can also vote to recommit the bill to committee, which is a signal to drop the bill or change it significantly. And of course, if either House fails to give a bill a majority of votes, then it dies. This applies to compromise bills coming out of conference committees too. Even if a bill gets a majority of both houses, then there's that whole veto thing that the president can do. Remember? So, there are many more ways for a bill to be killed than to become a law. These hurdles are sometimes called veto gates. They can't call them Bill Gates because that's a person. Veto gates make it very difficult for Congress to act unless there is broad agreement or the issue is uncontroversial, like naming a post office or thanking specific groups of veterans for their service, which are two things that Congress actually does pretty efficiently. I mean, think of all the post offices that aren't named. You can't think of one, can you? Name it. You can't. It's not named. Veto gates are purely procedural, which means they don't draw a lot of attention from the media. The easiest way for Congress to kill bills is to simply not vote on them, or even schedule votes for them. This way they don't have to go on record as being for or against a bill, just whether they support having a vote. And constituents rarely check up on this sort of thing. So I hope I managed to do a good job of both explaining how a bill becomes a law and why it's difficult for most bills to pass. And I hope I looked good doing it as well. This might be frustrating, but it's strangely comforting to consider that Congress and the government as a whole were designed to make it difficult to get things done. A single super powerful executive like a king can be very efficient, but also tyrannical. We don't like tyrannical around here. The founders set up these structural hurdles of the bicameral Congress and the presidential role in legislation to reduce the likelihood that authoritarian laws would pass. Congress added procedural hurdles like committees and filibusters for the same reason. You can argue that Congress has become dysfunctional, but looking at the process of lawmaking, it's hard to argue that this isn't by design. So next time someone accuses you of being difficult, you just say, I was behaving in a senatorial manner.
What we're going to do in this video is diagram out how a bill can become a law. And I make a distinction between a non-tax bill and a tax bill, because a non-tax bill can be introduced into either chamber of Congress initially. It could be introduced into the Senate, or it can be introduced into the House of Representatives, while something that deals with taxation can only be introduced initially into the House of Representatives. And as we've talked about in other videos, anyone can be involved in the drafting of a bill, but it actually needs to be introduced into the appropriate chamber by a member of that chamber. But let's say that it gets introduced into the Senate. What happens then? Well, it will be referred to the appropriate committee. And what is the appropriate committee? Well, if it deals with foreign relations, it would go to the Foreign Relations Committee. If it deals with the armed services, well, it would go to the Armed Services Committee. You get the general idea. Now in the committee, they might have hearings, they might debate it, and if they decide to debate it and have a vote on it, it could pass. So let's say it passes through the committee. And then the majority leader, and the majority leader is the leader of the majority party in the Senate. They have a lot of influence on how and when that bill gets debated on the Senate floor. But let's say that they schedule it for debate on the Senate floor. Once things get to a vote on the Senate floor, they need a simple majority to pass. So let's say that this bill passes. And I know what you're thinking. You might have heard numbers like 60 out of 100 votes or a 2/3 majority. where the 2/3 is necessary to ratify a treaty. The 60 votes, that's necessary for cloture to end most filibusters. And so functionally, it often does require more than a simple majority support in order to get even to a vote. But let's say that this bill that was initially introduced into the Senate makes it all the way through. What happens then? Well, if there isn't a similar bill that was introduced into the House of Representatives and got through the House of Representatives, this bill would then go through a similar process in the House. So then this bill would go all the way, it would be introduced into the House of Representatives. It would be referred to the appropriate committee. And then once it passes through the appropriate committee, it would go through the Rules Committee. And the Rules Committee is one of these major distinctions between the House and the Senate. The Senate does have a Rules Committee, but it is nowhere near as powerful. In the House, the Rules Committee can control a lot. It can decide when and how or even whether a bill even gets to the floor. But let's say it does get to the floor, and then it gets a simple majority of the House members to vote for it. Well, then this bill would then go to the president. Now, some interesting things happen once it gets to the president. The president can, of course, decide to sign the bill. So then sign the bill, in which case that bill will become law. The president could also decide to veto the bill. Now, if the president vetoes the bill, it would go back to the chamber in which it originated. In this first example that we are talking about, that vetoed bill would go back to the Senate. And in order to override the veto, they would need a 2/3 majority. And even if they were able to get the 2/3 right over here, it still wouldn't become a law. Then it would have to get the 2/3 in the House. But if it was able to get the 2/3 there as well, well then they have overridden the president's veto, and it will become a law. Now there's other edge cases that involve the president. If a president does nothing for 10 days, and if Congress is in session for those 10 days, well then it can become a law. So nothing for 10 days, well then you can also make it a law. And there's also something called a pocket veto, where the president does nothing, but the Congress goes out of session within that 10 days. And so let me do this. This would be a pocket veto right over here. And I'll just put that in quotes, because that's also the president doing nothing, but Congress goes out of session within those 10 days. Now, one thing to be clear, even what I've drawn here is a simplification. There are many steps in this process where a bill could change, where a bill could die, or a bill could just go into some sort of a limbo state. For example, a committee can decide to add to a bill. That would be called amending a bill. So that could happen over there. It can actually happen other places. Maybe a bill does not pass through committee. Not pass. Maybe it does not pass through the floor action. Maybe it doesn't pass the House committee. Maybe it doesn't pass through the House. All of these places are where a bill could die. There's also situations where a committee could decide to table a bill, which is not saying that we have voted against it, but they're saying, hey, we're not even going to vote on it, and it just goes into a little bit of limbo, but essentially the bill will die there. So it could get tabled in committee, in either chamber. Even the Rules Committee could decide to table it, so it never really makes its way to a vote on the floor. Now, it's also important to note that in the example we gave, a bill started in the Senate, made its way through the Senate, and then had to make its way through the House, and eventually got to the president's desk. It could have gone the other way. It could have started in the House of Representatives. In fact, if it's a tax bill, it would have had to start in the House of Representatives. And if it got all the way through the House, then it would have gone to the Senate. It would have to go all the way through the Senate, and then it would end up on the president's desk. And oftentimes, you have a situation where two parallel bills are making their way through each chamber. So there could be a bill that's making its way through the Senate, say on immigration, and there could be a parallel bill on immigration making its way through the House of Representatives. Now, if each of those bills get through their respective chambers, then they go to something called a conference committee, which is a place where both representatives and senators of the appropriate committees will get together and make their bills gel together. Now, even if they're able to agree to a unified bill, so to speak, one that syncs the two bills that went through both chambers, then that synced bill would once again have to go through both chambers again. So it's not like the conference committee can just decide. And even what I've drawn here is a simplification. There's all of this, whether you consider it interesting or not, parliamentary procedure and nuances that allow different players, especially the leadership in each of the houses, to have a lot of levers to either accelerate the passage of a bill or to kill it in different ways.
These 100 people are the U.S. Senate. They pass laws. They vote, and when a majority says yes, it passes. But these days, the Senate doesn't do that very often.
The Senate holding 2 votes, both failed. It's completely dysfunctional.
4 versions of gun control proposals, and all 4 failed.
See, the Senate has this rule. It says before they vote, 60 people have to agree to have the vote. That means just 41 people, a minority, can entirely block a bill. This is called a filibuster. Early on, filibusters were rare. This is a chart of the number of times the Senate has had a vote to break a filibuster in the last 100 years. But in the last 50 years, they started to grow. And now, almost every big bill is filibustered. The US Senate is broken, and the filibuster broke it. But the Senate didn't always have this rule. In fact, it all kind of happened by accident. This is the Senate in 1805. It's much smaller than it is now, and the filibuster as we know it today doesn't exist yet. And before they vote on a bill, they debate. If they want to end debate and vote, they just need a majority to agree. But Vice President Aaron Burr thinks a high-minded place like the Senate should have as much debate as needed. So the Senate gets rid of the rule. Now senators can debate for as long as they want, and there's no way to stop them. This is the beginning of the Senate filibuster. At first, it isn't really a problem. Because the Senate is still pretty small, there's only so long a group of senators can physically talk. Eventually they tire out, debate ends, and they get to a vote. But as the US grows, so does the Senate, and they have more factions and more people to filibuster bills. They move to a bigger room, and now it's 1917. World War I is underway, but the US isn't involved. Then President Woodrow Wilson asks Congress to authorize a broad military action. A group of senators don't want to give Wilson the power to enter the war, so they decide to debate until the session ends, filibuster. Woodrow Wilson is mad, and he demands that they go back to the old Senate rules, that debate can be ended with a simple majority. The Senate doesn't want to do that, so instead they compromise. They change the rules so they can end debate with the approval of 2/3 of the Senate, so that if senators want to block a bill, they need a third to do it. This is basically the system we have today. A supermajority to agree to vote, then a simple majority to pass a law. And for a few decades, the filibuster is used, but pretty sparingly. Then in the 1950s, the Senate starts to consider civil rights legislation, and Southern senators really hate this. But they don't have the votes to actually defeat the bills, so they start using the filibuster to block bills. Here's South Carolina Senator Strom Thurmond. He looks tired because he just filibustered the 1957 Civil Rights Act for more than 24 hours. These filibusters are painstaking, and they block the Senate from actually doing work. The majority leader at the time, Mike Mansfield, doesn't like this. He's okay with needing a supermajority to pass things. What he doesn't like are these long, pointless speeches. So he makes a change. He skips the debate and goes directly to a vote to see if there's a supermajority to end debate. This means if senators want to filibuster, they don't have to stand up and talk. They can just threaten to, as long as they have the numbers to block a supermajority vote. This makes it way easier to filibuster. And the number of filibusters grows. In the mid-70s, the Senate changes the threshold needed to filibuster. Now instead of 34 senators, you need 41, but it doesn't make much of a difference. And then around the 2000s, senators in the minority start to realize something. They can gain more politically by fighting than by cooperating. So they filibuster everything the other party wants to do. That's what leads to this spike. Now, almost every big bill is filibustered. Finally, in 2013, the Democratic majority makes a change to the rules that says the filibuster no longer applies to certain confirmation votes. In 2017, the Republican majority makes another similar change. Both times, it feels like a huge deal. But now, things are beginning to change. The 2020 elections are coming up, and Democrats have some big proposals.
Healthcare in America.
Federal investment in teachers' salaries.
Investments in clean energy.
But Democrats know even if they have a majority in the Senate, they're not going to get the 60 votes needed to overcome a filibuster. And that's why a new idea is now on the table.
Would you urge the Senate Democratic leader to get rid of the filibuster?
I think we have to have that on the table.
To get rid of the filibuster.
Get rid of the filibuster.
Getting rid of an old tradition naturally feels radical. But here's one more story about the filibuster. The Senate is only one half of Congress. The other half, the House of Representatives, also used to have rules that allow the minority party to filibuster bills. Then, in 1888, Republicans won control of the House, but the filibuster rules kept them from actually passing anything. It was like the election, and ultimately the will of the people didn't even matter. So, they got rid of it. And the reasoning was pretty simple. If the party that loses an election can block the winners from doing anything, what does it mean to be a democracy?
On January 1st, 1863, Abraham Lincoln legally changed the status of over 3 million enslaved blacks across 10 states from slave to free. His Emancipation Proclamation wasn't a law or a presidential decree. It was an executive order. The framers of the American Constitution made the power of the executive order available to the executive branch. But what exactly is this tool? How does it work? And what is the extent of its power? Well, an executive order isn't a law, but it can carry the weight of one. Passing laws involves a fairly lengthy process. First, a member of Congress proposes a piece of legislation in the form of a bill. After many committees and revisions, if the bill is approved by a majority of votes in Congress, that is, both the House and Senate, the bill is then sent to the President for signature. If the President signs the bill, it then becomes a law. An executive order, on the other hand, is something the President issues without consultation or permission from Congress. They are, however, enforced like laws and are subject to judicial review by the court system to make sure they're within the limits of the Constitution. That means the courts have the power to invalidate any executive decisions that they determine are an overreach of the President in trying to assert power. And once the President leaves office, if his or her successor wants to eliminate the executive order, they can do so. So when does a president use an executive order? Sometimes a president feels the need to exert power without working with Congress, and in times of crisis, quick decisions can be justified. But most executive orders are not responses to emergencies. They're often directed towards agencies in the federal government in order to expand or contract their power. Others determine the extent to which legislation should be enforced. And sometimes, a president may use an executive order to clarify and help implement a policy that needs to be easily defined. Some of the most famous executive orders have changed the course of American history. FDR issued an executive order to establish the Works Progress Administration, which helped build thousands of roads, bridges, and parks throughout the country. The WPA also employed thousands of writers, painters, sculptors, and artists to create works of art in public spaces. Additionally, Harry Truman used an executive order to desegregate the armed forces in 1948. And in 1965, Lyndon Johnson signed an executive order to establish requirements for non-discriminatory practices in hiring and employment. Executive orders have often been used in positive and inclusive ways, but they've also been used to exclude and divide. One of the most notable examples being FDR's 1942 executive order. He gave the military authority to target predominantly Japanese Americans, as well as German Americans and Italian Americans in certain regions across the country. This executive order also removed any or all of those people into military zones, most commonly known as internment camps. Beginning in the early 1960s, each president has issued roughly 300 executive orders, but FDR issued over 3,500. At the other end of the spectrum, William Henry Harrison never issued an executive order, probably because his presidency only lasted 31 days. The U.S. Constitution is somewhat ambiguous on the extent of the president's power. That's resulted in executive orders expanding over time. For instance, since Lyndon Johnson, presidents have begun issuing orders to create faith-based initiatives, establish federal agencies, and remove barriers for scientific research. There are checks and balances in the U.S. political system. Congress can pass laws to counteract executive orders, and judges can halt them by deeming them unconstitutional. But in the time it takes for those things to happen, an executive order can go into effect and possibly change the course of history, for better or for worse.
As you probably remember, because you're a smart rememberer of things, the American court system is hierarchical, which means any discussion of it cries out for a visual representation. Thought bubble, like Drake, will start from the bottom. The trial courts have original jurisdiction. When you realize that there are 50 states, each with its own court system, it shouldn't be surprised that the vast majority of cases start out in state courts. Of course, most cases never get to court at all. The vast majority of disputes, criminal and civil, are settled outside of court. How is that for efficiency? On the federal side, the trial courts are the U.S. district courts. There are 94 of them, with 663 judges, more or less. Sometimes in civil cases, a plaintiff, the person bringing the case, will have a choice about whether to bring that case in state or federal court. But you can only start in the district courts if your case meets certain important criteria. Almost all criminal cases start in state courts. So if you don't like the result in the trial court, and you have a reasonable claim that there was something procedurally wrong with the case, or the way the law was applied, you can bring an appeal. Notice that if you start in state courts, you usually have more chances for appeal, because most states have 2 levels of appellate courts, and the federal system has 1. Appeals courts can refuse to hear appeals, and if they do, you're done. One thing to remember, the loser can always try to appeal, even if that loser was the state that failed in its prosecution. Federal appeals courts are called circuit courts, and there are 12 of them, distributed regionally throughout the U.S. You might guess if the region where your case is heard matters, and you'd be right. Judges in the 9th Circuit, which includes California and Oregon, tend to be more liberal than judges in the 5th Circuit. Federal appeals are usually heard by panels of 3 judges, while trials in the district court are before a single judge. There are 4 scenarios where the federal courts have original jurisdiction, and in all cases, they must be brought in a district court. They are cases where the law at issue is a federal law, like a claim against Obamacare. Cases involving treaties, which are by definition federal laws. These are pretty rare and really interesting. Cases involving the U.S. Constitution, for example, a case concerning freedom of religion. And cases where the U.S. government is a party to the litigation. The other type of case that can go into federal court is one involving more than one state where there's more than $70,000 at issue. This makes sense because if the parties in dispute are in different states, they might not even agree where to have the trial, and federal judges are supposed to be more impartial than state judges. Thanks, Thought Bubble. So thoughtful. So bubbly. If you read the news and pay attention to legal cases, most of what you see are lower court decisions, at least until the spring when the Supreme Court starts handing down decisions. These are the ones that tend to make it into the history books and that you may have even heard of. But how does a case get to the Supreme Court, Craig? Well, I will answer that for you. That's my job. Most of the time, the Supreme Court has appellate jurisdiction. In fact, it's the final court of appeals. If you lose there, you've really lost. When the court hears a case, it's called judicial review. There are, however, circumstances when the Supreme Court has original jurisdiction and can act like a trial court. So it's a good thing that most of the justices are, in fact, lawyers, although there's no constitutional requirement that they need to be. If the court has original jurisdiction in cases between the U.S. and a state, cases between 2 or more states, cases involving foreign ministers or ambassadors, and cases brought by citizens of one state against citizens of another state or against a foreign country. What do these cases have in common? The main thing is that you can't imagine there being a single state where they could happen. This is especially true in cases involving foreign officials. And then there are my favorite Supreme Court cases, crimes committed on the high seas. That's right, the Supreme Court can exercise original jurisdiction over pirates. This is not as weird as it sounds because crimes on the high seas, by definition, have not happened in any state. So where are you going to have the trial? But most of the time, cases that make it to the Supreme Court are there on appeal. In order for the court to exercise its appellate jurisdiction, the case must raise a federal question. For example, one involving due process or equal protection or an important federal statute. If you don't know what those terms mean, don't worry. We'll get to them. Here's the thing though, the Supreme Court doesn't hear a lot of cases. It doesn't want to, and I don't want to either. I understand. They also can't, and it's not just because most of the justices are kind of old. It's because there are only 9 of them, and they get requests to review about 8,000 cases a year. Out of these, they actually hand down about 80 decisions, so they have decision rules to weed out the cases that they don't want to hear. The first one is that there has to be a case or controversy, which means that you can't request the court to review whether or not a law is unconstitutional before it has gone into effect. There has to be an actual injury first. Another way of saying this is that the Supreme Court will not issue advisory opinions, speculating on whether or not a law might violate the Constitution. The second hurdle a potential Supreme Court litigant has to get over is called standing. Oh, that sounds terrible. I wouldn't want to be standing. No, this means that in order to bring a case, the parties must have a substantial stake in the outcome, which usually means an actual injury. Lack of standing is one reason that the court has refused cases about same-sex marriage brought by opposite-sex married people. The court will also refuse to hear a case that is moot. Mootness, which is a real word, I promise, I'm reading it on a teleprompter, means that the case no longer requires a resolution, say because one of the parties is dead. The flip side of mootness is ripeness. If a potential injury has yet to occur, the case is not ripe. It's like a hard avocado. Your guacamole, just not going to be very good. It's best not to be too anxious about bringing your case. Most of the time you can wait, except in cases like Bush v. Gore, where we kind of needed an outcome so a new president could move into the White House. There's also a vague decision rule called the political question doctrine. In some cases, the court would rather that the executive or legislative branch handle the issue and not get involved. There are certain cases that the court will almost always take, even though all things being equal, they'd rather not. When the circuit courts have reached different or conflicting conclusions on the same issue, what's known as a circuit split, the court will usually hear the case to resolve the confusion. The court will also almost always hear a case where the federal government itself initiated the appeal. Finally, the Supreme Court will usually take a case that has a clear constitutional question, like one involving freedom of speech or religion, although there are sometimes constitutional issues that they feel are settled or they just don't want to deal with. For a long time, for example, the court didn't hear gun control cases, and nowadays they don't usually take obscenity cases. Okay, so that's the structure of the court system and how a case does, or usually doesn't, make it to the Supreme Court. What we haven't really discussed is what happens when a case does make it to the Supreme Court. We'll show you that next time when we take a shortcut to the Supreme Court by suing the ambassador to Switzerland for making such delicious chocolate. It's making me unhealthy. When you think of the Supreme Court, the first thing you think about, other than those comfy robes, is the power to declare laws unconstitutional. The term for this awesome power, the main check that the court has on both the legislative and executive branches, is judicial review. Technically, judicial review is the power of the judiciary to examine and invalidate actions undertaken by the legislative and executive branches of both the federal and state governments. It's not the power to review lower court decisions. That's appellate jurisdiction. Most people think of judicial review as declaring laws unconstitutional, and that definition is okay. But legal purists will quibble with you since judicial review applies to more than just laws. Appellate courts, both state and federal, engage in some form of judicial review, but we're concerned here with the federal courts, especially the U.S. Supreme Court. The court has the power to review the following. 1. Congressional laws, aka statutes. Since judicial review is a form of appellate activity, it involves upholding or affirming the validity of laws, or denying it, invalidating the law in question. You might think that the Supreme Court does this a lot, but it doesn't, and historically it almost never happened before the 20th century. If the court were always striking down congressional statutes, it would be hard for people to know which laws to follow, and you'll remember one of the main things that courts do is create expectations and predictability. For instance, you could predict that I would eventually be punching this eagle. Another reason why they don't invalidate laws often is that if the court frequently overruled Congress, the court would seem too political and people would stop trusting its judgment. If the court has any power at all, it largely stems from its prestige and reputation for being impartial and above politics. No one has any problems with the Supreme Court decisions at all. 2. The court can also overturn state actions, which include the laws passed by state legislatures and the activities of state executive bureaus, usually the police. The power to review and overturn states comes from the Supremacy Clause in the Constitution. Most of the time that the Supreme Court extends civil rights, it comes out of a state action. A good example is Brown versus Board of Education, where the court struck down the idea of separate accommodations being equal in the context of state public schools. 3. The court can review the actions of federal bureaucratic agencies, although it will usually defer to the bureaucrat's expertise if the action is consistent with the intent of the legislature, which the court usually finds it is. The court almost never strikes down congressional delegation of power to the executive, although you might think that it should. The fourth area where the court exercises judicial review is over presidential actions. The court tends to defer to the president, especially in the area of national security. The classic example of the court overturning executive action happened in U.S. versus Nixon, where the justices denied the president's claim of executive privilege and forced him to turn over his recordings relating to the Watergate scandal. More recently, the court placed limits on the president's authority to deny habeas corpus to suspected terrorists in Rasul versus Bush. So, the Supremacy Clause gives the court the authority to rule on state laws, but where exactly in the Constitution does the power of judicial review come from? Trick question! It's not there. Go ahead, look, I'll wait. See? Not there. Wow, you went through that whole thing really quickly. Fast reader. The crazy thing is that the power of judicial review comes from the court itself. How? Let's go to the thought bubble. The Supreme Court granted itself the power of judicial review in the case of Marbury versus Madison. You really should read the decision because it's a brilliant piece of politics. The upshot of the case was that Chief Justice John Marshall ruled that the court had the power to review, uphold, and strike down executive actions pursuant to the Judiciary Act of 1789, and in doing this, to strike down part of that federal law. How he got there was pretty cool. So Marbury was an official that President John Adams, at the very end of his term, appointed to the position of Justice of the Peace. When Marbury went to get his official commission certifying that he could start his job, James Madison, who was Secretary of State, refused to give it to him. So Marbury did what any self-respecting petitioner would do. He went to the Supreme Court for a writ of mandamus that would force Madison to give Marbury his job. This is what he was supposed to do according to the Judiciary Act of 1789. What Marshall did was brilliant. He ruled that yes, Marbury had a right to the commission, but that the Supreme Court could not grant his writ because the law directing them to do so was unconstitutional. This is brilliant for two reasons. First, by the time the case came before the court, Thomas Jefferson was president. Those of you who remember Crash Course U.S. history will recall that that less handsome man told you that Jefferson was a Democratic Republican, while Adams, Marbury, and even Marshall were all Federalists. By ruling against his own party, Marshall made a decision that was favorable to Jefferson, and thus likely to be supported. The second move is even cooler. Marshall's ruling took the power to grant writs of mandamus away from the court, making it look weaker, while at the same time giving the court the power to declare the law that had granted it the mandamus power in the first place unconstitutional. So by weakening the court in this instance, like Daredevil going blind as a kid, Marshall made it much stronger for the future, like Daredevil getting stronger in the future. Thanks, Thought Bubble. So that's where judicial review comes from, but that still leaves many questions. A big question is, why has this ruling stuck around and hasn't been overturned by other laws or later court decisions? Another question is judicial review a violation of separation of powers? Some say that it's judges making laws, and thus an anti-democratic usurpation of the legislature's power. Let's talk about this ruling's longevity first. Remember when I said last time that the Supreme Court rulings are binding in lower courts? You don't remember, do you? You were sleeping. Wake up! Well, in general, Supreme Court precedents are binding on future Supreme Courts too because of the principle of stare decisis, which is Latin for let the decision stand. This doesn't mean that future Supreme Courts can never overturn the decisions of prior courts, it's just that they try very hard to not do it. This idea of precedent is one way that judges can be said to make laws. Appellate decisions are like common law in that they're binding on future courts and constrain their decisions and because they don't have to be grounded in a specific statute. Other courts have to follow the higher court's interpretation of the law, and this interpretation has the effect of redefining the law without actually rewriting the statute. On the other hand, appellate decisions are technically not common law in that they are only binding on courts, not executive agencies or legislatures. They are, however, signals to courts and legislatures about how courts will rule in the future. Maybe an example will help. If you watch cop shows or you get arrested a lot, you probably know something about Miranda versus Arizona, which gave us the Miranda warning. You have the right to remain silent and all that stuff. Hopefully you've never heard that in person though, but hey, we're not here to judge. That's what the courts are for. Okay. In that case, the Supreme Court threw out Miranda's conviction because he hadn't been told that he had the right to remain silent. Without knowing that he didn't have to talk, he made a confession that got him convicted. The court didn't rewrite Arizona's law, but it sent a signal to Arizona's law enforcement agencies and those in all the other states that in the future, courts would throw out the convictions of defendants who hadn't been informed of their rights. As a result, police procedures changed in every state, and now the police are supposed to read the Miranda rights to anyone they arrest. So those are the very basics of judicial review. We've probably raised as many questions as we've answered, but that's why we're making a bunch of these videos, so we can teach it all. All of it. Anyway, the big concern for many is that cases like Marbury versus Madison, which give courts the power to strike down pieces of legislation, overturn the judgment of the elected representatives that made the laws and violate the idea of separation of powers. Well, that is a thorny issue, but it's one we don't have time to de-thorn today. For now, understand that judicial review is how the courts work in practice, and not necessarily a defined power granted by the Constitution. Just remember, the executive and legislative branches also operate with a lot of implied powers that aren't explicitly granted to them in the Constitution. That's because the governance of the United States has evolved and changed over time to hopefully suit the needs of the country as they change over time.
There's a job out there with a great deal of power, pay, prestige, and near-perfect job security. And there's only one way to be hired: get appointed to the U.S. Supreme Court. If you want to become a justice on the Supreme Court, the highest federal court in the United States, 3 things have to happen. You have to be nominated by the President of the United States. Your nomination needs to be approved by the Senate. And finally, the President must formally appoint you to the court. Because the Constitution doesn't specify any qualifications, in other words, that there's no age, education, profession, or even native-born citizenship requirement, a president can nominate any individual to serve. So far, 6 justices have been foreign-born. At least one never graduated from high school. and another was only 32 years old when he joined the bench. Most presidents nominate individuals who broadly share their ideological view. So a president with a liberal ideology will tend to appoint liberals to the court. Of course, a justice's leanings are not always so predictable. For example, when President Eisenhower, a Republican, nominated Earl Warren for Chief Justice, Eisenhower expected him to make conservative decisions. Instead, Warren's judgments have gone down as some of the most liberal in the court's history. Eisenhower later remarked on that appointment as the biggest damn fool mistake he ever made. Many other factors come up for consideration as well, including experience, personal loyalties, ethnicity, and gender. The candidates are then thoroughly vetted, down to their tax records and payments to domestic help. Once the president interviews the candidate and makes a formal nomination announcement, the Senate leadership traditionally turns the nomination over to hearings by the Senate Judiciary Committee. Depending on the contentiousness of the choice, that can stretch over many days. Since the Nixon administration, these hearings have averaged 60 days. The nominee is interviewed about their law record, if applicable, and where they stand on key issues to discern how they might vote. And especially in more recent history, the committee tries to unearth any dark secrets or past indiscretions. The Judiciary Committee votes to send the nomination to the full Senate with a positive or negative recommendation, often reflective of political leanings, or no recommendation at all. Most rejections have happened when the Senate majority has been a different political party than the president. When the Senate does approve, it's by a simple majority vote, with ties broken by the vice president. With the Senate's consent, the president issues a written appointment, allowing the nominee to complete the final steps to take the constitutional and judicial oaths. In doing so, they solemnly swear to administer justice without respect to persons, and do equal right to the poor and the rich, and faithfully and impartially discharge and perform all the duties incumbent upon a U.S. Supreme Court justice. This job is for life, barring resignation, retirement, or removal from the court by impeachment. And of the 112 justices who have held the position, not one has yet been removed from office as a result of an impeachment. One of their roles is to protect the fundamental rights of all Americans, even as different parties take power. With the tremendous impact of this responsibility, it's no wonder that a U.S. Supreme Court justice is expected to be, in the words of Irving R. Kaufman, a paragon of virtue, an intellectual titan, and an administrative wizard. Of course, not every member of the court turns out to be an exemplar of justice. Each leaves behind a legacy of decisions and opinions to be debated and dissected by the ultimate judges, time and history.
Old TV shows made it seem really easy to appeal to the Supreme Court, like when this lady wanted to fight her speeding ticket.
I am going to win this case. If not here, I'll appeal to a higher court. If necessary, I'll take it to the Supreme Court.
Or on Gilligan's Island, when Thurston Howell is locked in a bamboo jail and he says,
I'll take it to Supreme Court.
But even though they make it sound like a right, nobody is entitled to an appearance at the Supreme Court. That's entirely at the discretion of the justices. And they choose very carefully. Only a small number of cases get to the Supreme Court, and it's getting smaller. Roughly 8,000 cases are submitted each year, but only 80 cases are accepted. That's a 1% acceptance rate. And to get to that 1%, most cases start at the bottom. The federal court system consists of 3 layers, and the lowest is the district level. If you lose in a district court, you can appeal to the circuit level. Most of the United States is divided into 11 circuits, but there's a 12th for DC and a federal circuit that mostly hears patent and military cases. Above the circuit level is the Supreme Court, the highest court in the land, as long as you don't count the basketball court that's above the Supreme Court. And to get to the Supreme Court, nearly all cases require submitting something called a petition for a writ of certiorari,
the writ of certiorari, which is shortened usually to writ of cert.
A petition for the writ of cert is a written request asking the Supreme Court to hear a case, instead of asking the court to resolve the facts of a case, which are nearly always settled in lower courts. The reasons for granting the petition concern important questions about federal law.
The overarching goal of the court is to make sure that federal law is the same across the country. And so by federal law, I mean the U.S. Constitution and laws passed by Congress.
Professor Green clerked for Justice John Paul Stevens, where he became very familiar with cert petitions. That's because the clerks review cert petitions for their justices, who then choose to grant a petition if it passes the rule of 4, meaning that 4 justices want to hear the case. When the court does not grant cert, it does not imply a decision.
It doesn't mean that it agrees with the lower court. It doesn't mean that the individual justices agree with the lower court decision. It just means that the court has decided that this particular case is not a case where the court is going to choose to set the law for the whole country.
If cert is granted, a case probably falls into one of 3 categories describing most Supreme Court cases. The first is a case of national importance, such as when the court decided Bush v. Gore in order to help determine who had won the 2000 presidential election.
Drawing on very rarely used legal powers, the Supreme Court has, for the first time in American history, decided to step into a legal dispute in the midst of a presidential election.
A second type of case is when a lower court issues a ruling that invalidates federal law. An example is Gonzalez v. Raich, in which Angel Raich, a California woman, challenged federal drug laws after agents destroyed marijuana plants she had been consuming for medical use. On her appeal in the Ninth Circuit, judges ruled in favor of Raich, deciding that she was compliant with the state law authorizing her use of medical pot. But that ruling conflicted with federal law prohibiting marijuana use.
So when the Ninth Circuit said it doesn't apply, that means if you're a medical marijuana user in California, then you can use it without fear of federal prosecution. But if you are a medical marijuana user in Florida or in New York, then it's still banned under federal law.
By ruling on the case, justices were able to establish the authority of federal law prohibiting the use of medical marijuana.
In the Raich case, the Supreme Court overruled the Ninth Circuit and said that the federal drug laws can apply to local marijuana use, which means that someone like Angel Raich can still be prosecuted under federal law, even though she can't be prosecuted under state law.
Third, the court accepts cases in order to resolve a split decision in the lower courts. This happened in the case of Obergefell v. Hodges, where a Sixth Circuit ruling that banned same-sex marriage conflicted with rulings in other circuits that had upheld the right to same-sex marriage.
The Obergefell was someone living in Ohio who wanted to marry his same-sex partner and was not permitted to do so under Ohio law. It made its way to the Sixth Circuit. The Sixth Circuit said you have no right to be married because you're a same-sex couple. And that created a split, a division of authority between the Sixth Circuit, which governs Ohio, and a number of other circuit courts. And so once that happened, it was fairly clear to, I think, most legal observers that the Supreme Court was likely to hear the case because it meant that the federal law, the federal constitution in this case, applied differently in Ohio than it would in Pennsylvania, for example.
By ruling in favor of Obergefell, the court resolved a circuit split and made same-sex marriage a right nationwide. But these 3 categories are just a framework for understanding why the court might select a case. They are not rules. Ultimately, which cases get to the court depends on the decisions of individuals, the sitting justices of the U.S. Supreme Court.
President Trump really dislikes these judges.
The Ninth Circuit is a disaster. Nobody can believe these decisions we're getting from the Ninth Circuit. It's a disgrace. The Ninth Circuit, everybody knows it. It's totally out of control.
When Trump took office, most of the Ninth Circuit's judges had been appointed by Democratic presidents, and they overruled some of Trump's most provocative executive orders. The travel ban, emergency funding for a border wall, they all stopped here.
Very hard to win at the Ninth Circuit, if not impossible.
But that's changing.
We're slowly putting new judges in the Ninth Circuit.
Trump has already added 7 new judges to the Ninth Circuit Court of Appeals. And by the end of his first term, there's a good chance that the Ninth Circuit could look very different. We usually think of the 3 branches of government as the President, Congress, and the Supreme Court. But it's down here in the lower federal courts where President Trump is building his longest-lasting legacy.
You know, when I got in, we had over 100 federal judges that weren't appointed. It was like a big, beautiful present to all of us.
Federal courts hear lawsuits involving the Constitution or laws made by Congress. Say a city pays a female employee less than her male counterpart. That violates the Equal Pay Act, a federal law. So that case would start here, where all federal lawsuits start, in a district court. There's at least one in every state. For example, California is home to 61 judges who serve on the state's 4 district courts. If the case is appealed, it moves up to the aptly named Court of Appeals. It's made up of 13 circuit courts, and they each hear cases from different parts of the country. So a case that started in California will move up to the Ninth Circuit Court because they hear cases from the western part of the U.S. If it's appealed again, it'll go to the Supreme Court. But they only hear less than 100 cases a year. The circuit courts, they hear 50,000. For most federal cases, these judges give the final precedent-setting ruling. They're kind of a big deal. And every single judge here is nominated by the president and serves for life. Now here's a chart showing how many circuit court judges a president confirmed by what time in their presidency. There's Ronald Reagan's, and this is George H.W. Bush's, Bill Clinton, and George W. Bush. All pretty consistent, right? Now here's Barack Obama's. Look how it totally flatlines in his last 2 years. That's because all federal judges are nominated by the president, but then have to be confirmed by a vote in the Senate. And after the 2014 election, Republicans gained control in the Senate, and Mitch McConnell stopped holding votes on nearly all of Obama's court picks, from the Supreme Court all the way down to the district courts. So when Trump took office, not only did he have a ton of vacant seats to fill, he had a Republican-controlled Senate to help fill them, quickly. In fact, Trump has appointed more circuit court judges in the first half of his first term than any other modern president. But his judges are different. This is where all the judges nominated by each president fall on a scale between liberal and conservative, determined by their past political donations. And here's the median score for those judges. You can see that appointees on both sides have moved further to the left and right of their party's medians. But Trump's median pick is more conservative than Obama's was liberal, and more conservative than his Republican predecessors. And if you look at the ideological distribution of judges appointed by previous presidents, you can see tails at either end. Both Republican and Democratic presidents appointed some judges that leaned the other way, but Trump, not really. Traditionally, presidents need to work with the Senate. If a judgeship opens up in, say, Texas, the nominee would need the approval of the Texas senators. No approval, no vote. It makes presidents compromise with the opposite party and prevents them from stacking the courts with super partisan judges. That's why these past presidents had to have a spectrum of judges. But when Trump nominated 2 men for seats on the Ninth Circuit, the court that keeps overturning Trump's executive orders, the 2 Democratic senators from California opposed both of them, calling them far outside the judicial mainstream. One because of some controversial writings in college, and the other because of his prior work as a defense lawyer, including for oil companies where he argued climate change isn't real. Normally, this would mean they would never get a vote, let alone a hearing. But Republicans aren't honoring the century-old informal rule, and judges are being confirmed without the support of either home state senators, including those 2 on the 9th. Trump has now appointed 7 new judges to the Ninth Circuit, 1 because Obama's nominee wasn't allowed a vote, and 4 without the approval of home state senators. He's expected to appoint at least 2 more judges before his first term is over. This is what the circuit courts looked like when Trump became president at the beginning of 2017. And here's how the courts look halfway through 2019. It's expected that every president gets to have an impact on the federal courts. That's normal. But Trump only got to fill these seats because of McConnell's refusal to hold a vote on Obama's picks. None of these Trump picks had the support of both senators from their home state. And as a group, Trump's picks are more conservative than his Republican predecessors. In 2018, Mitch McConnell laid out his goals for the federal judiciary in a radio interview.
Appointing and confirming these strict constructionists to the courts who are in their late 40s or early 50s, and we're making a generational change in our country that will be repeated over and over and over down through the years.
And his plan is working.
Since the colonies got together and declared independence from Britain, the state governments have had an interesting relationship. In fact, until the Constitution was agreed upon, there was a lot of fighting over just how much of this independence that these states had just fought for would have to be given up to the new federal government they were creating. The structure they came up with is 2 in 1, an overlapping system where each state had its own government, and the new country had one as well. Separate and apart from the state governments, we call that government the federal government. And by government, we mean all 3 branches, the executive, the legislative, and of course, the judicial, which are the court systems. So each state has its own laws and its own courts, and the federal government has its own laws and courts. And just to make it extra complicated, either court, state or federal, can enforce the laws made by the other. It can be confusing because sometimes the federal courthouse is right across the street from the state courthouse. Which one is the right one for you? The answer depends on the court's jurisdiction. Jurisdiction is the court's power to hear certain kinds of cases. The rule of thumb is that state courts have the broadest jurisdiction. It may be the opposite of what you would guess, but the state courts have the power to hear a much bigger variety of cases than federal courts. So the majority of ordinary cases are most likely to be tried in state court. State courts handle about 30 times the cases the federal court does every year, which works out to around 90% of the total caseload. But federal court will take over in special situations. For example, federal courts have jurisdiction over cases where the United States is involved as a party, and cases involving direct violations of the U.S. Constitution or federal statutes. This is called federal question jurisdiction. Federal courts can also hear cases between people from different states if it's for an amount over $75,000. This is called diversity jurisdiction. Federal jurisdiction also covers cases dealing with bankruptcy, patenting, copywriting, or maritime law. That's the ocean. However, if a state law violates a federal law or the Constitution, this can be argued in state court. But it's important to remember that federal and state court work side by side, and one is not superior to the other. Each recognizes the other's potential jurisdiction over a case.
People who are arrested and charged with crimes in Central Florida have never been in trouble before. That means that they've never gone through the system and have no idea how it works other than what they've seen on TV. Because of this lack of knowledge and experience, the entire process can be frustrating, confusing, and terrifying if they don't have the right legal allies and support in place. Having the right criminal defense attorney doesn't just mean that your case will be handled competently, it also means that you have someone who can educate you about the process, tell you what to expect, and help you take the right actions to ensure that the situation has the least impact on your life, your reputation, and your future as possible. In this video, I'm going to give you a 30,000-foot look at a typical criminal case and how that case moves through the court system. A criminal case will start with either a physical arrest or a notice to appear issued by a law enforcement officer. If a person's arrested, they'll be transported to the county jail in which they were arrested. There, they'll have to be processed through the jail and then will either have a bond automatically assigned to them or will have a first appearance hearing in front of a judge at the jail. At that first appearance hearing, the judge will inform the individual of what they were arrested for. The judge will then set a bond if the person's eligible for one, and the judge will either appoint the public defender's office to represent the person or inform the accused that they have a right to hire a private attorney. Even if you're assigned a public defender, you still have the right to hire a private attorney. You do not have to use the attorney that the government assigns to your case. For most people, the time spent at the jail will be the worst part of their entire ordeal. Once they get bonded out and hire a good criminal defense attorney, most of the weight and the stress of the situation should be lifted off of them. The attorney should then take care of everything related to the case moving forward. After the accused bonds out of jail, they'll get a court date called an arraignment date. The arraignment date is usually held at the downtown courthouse for that particular county. An arraignment hearing is a formal court hearing where the charges filed against the defendant by the prosecutor are read aloud and the defendant is required to enter a formal response. This response will be a plea of either guilty, not guilty, or no contest. It's in the best interest of 99% of individuals to enter a plea of not guilty at this juncture because they have not had any opportunity to review the evidence against them and work out a good resolution to their case. By entering a plea of not guilty, it also allows the individual more time to hire a private defense attorney who can review the evidence against them and get the accused a better result or outcome than what they would have faced alone at the arraignment. If you hire an attorney prior to your arraignment, then you actually don't have to attend that arraignment at all. Your attorney will waive your appearance, enter a plea of not guilty on your behalf, and demand discovery from the state. It's in most people's best interest to hire a private attorney prior to their arraignment date. The faster you hire an attorney, the more time they have to get out in front of the prosecution and begin dictating the case instead of starting halfway through the game and needing to respond to the state's actions against you. Arraignments are usually not specific to the defendant, which means that there can be hundreds of people who all have their arraignment on the same day at the same time in the same courtroom. We actually call the arraignment a cattle call because there are hundreds of people there for their arraignment and they're called up one after the other after the other. If your last name starts with P, like mine, you'll probably be waiting there for hours for your case to be called. By hiring a private attorney, you wouldn't have to go to your arraignment date at all. The next court date is called either a pretrial conference or a docket sounding, depending on what county you're in. Between your arraignment and your first pretrial conference or docket sounding, a lot will happen. Your attorney will start to receive discovery from the state, that is, all of the evidence that the state has against you, and will also file reciprocal discovery, that is, all of the evidence that you're able to give to your attorney, such as pictures or text messages or something like that, depending on the charge. It could even be physical evidence like a torn shirt showing that you were attacked and acted in self-defense. Your lawyer will also start identifying witnesses that may need to be deposed or work on getting affidavits from those witnesses. Your lawyer should also begin working on and filing an exhibit list of the things to be used as evidence in your case. Sometime around that first pretrial conference or docket sounding, you'll also get an offer to resolve your case. This offer can either be a very reasonable offer or it can be a harsh and unreasonable offer. Your attorney should be able to tell you what they think is reasonable and what isn't based on your charge, the facts of your case, your criminal history, and the county that your charge is in. Depending on where the prosecutor is at with their offer at this stage, your lawyer may choose to continue the case to the next docket's pretrial conference or docket sounding and get more time to file certain motions to attack the state's case, such as a motion to suppress, a motion to dismiss, a motion in limine, or various other pretrial motions. These motions will then be set for evidentiary hearings. Based on the outcome of these hearings, the state's case can either be dismissed by the judge, dismissed by the state, or the state's case can be weakened for trial, and you may get a better offer. The state could also win these hearings, in which case they'll feel more confident about winning a trial and will likely stick to a harsh offer that they've already provided. So it's very important that your lawyer understands all the nuances about how prosecutors think and how the system really works before they just start filing motions just to file them. Your attorney should also know the relative strength of the case after reviewing and analyzing all the discovery, as well as conducting depositions of the witnesses to see what their testimony will be. Criminal defense is chess, not checkers, and everything that's done to defend a case must be done purposefully and strategically while weighing the pros and cons of each action. Most cases take about 6 to 12 months to resolve. Sometimes they can be much faster or take even longer. It all depends on a number of different factors. The fastest result is not always the best result. Some people need their case to end by a certain time due to life circumstances, while others even prefer that their case get dragged out. Each person's case and life situation are different, so we're sure to discuss all of this with you to understand your biggest concerns. Once all of the pretrial work is done and completed, the state will usually offer their final offer to resolve the case prior to trial. The decision to accept this offer should always be balanced with the risk that the defendant faces at trial. For example, if you have a charge for possession of cocaine, which is a third-degree felony, and your offer to resolve the case is 6 months of probation, a drug class, and some community service with no conviction, you'll need to balance either taking that offer or going to trial and risk losing. If you win at trial, the whole case goes away. But if you lose, you'd be a convicted felon for the rest of your life, and the judge can sentence you to up to 5 years in prison. The decision to accept an offer or go to trial is entirely the client's decision, but an experienced attorney should be able to answer questions and provide information that may help you make the right decision for you. A good criminal defense attorney will usually get you the best result possible. What that result is depends on various factors, such as a person's criminal history, the nature of the crime and any minimum mandatory sanctions, the prosecutor assigned to your case, the facts of your case, the judge, the county, the police's investigation and strength of their work, and a number of other factors. So to summarize, the process works like this. There's an arrest or notice to appear. The individual bonds out of jail. They hire a solid defense attorney who waives their appearance at the arraignment and enters a plea of not guilty while demanding all of the discovery. Then, a series of pretrial conferences or docket soundings occur, during which time your lawyer will file various pretrial motions, examine the evidence, provide your own evidence, depose witnesses, file various pleadings, and ultimately litigate while negotiating with the state to achieve the best offer possible for you to resolve your situation. At a certain point, all of that pretrial work will be done and you'll have what should be the best offer to resolve your case. And you'll then have to decide if you want to take that offer or if trial is a viable and better option.
In 1932, the Great Depression entered its third winter. 1 in 4 Americans was unemployed, marking the highest unemployment rate in the country's history. Tens of thousands had lost their homes and life savings, and there was very little confidence that Republican President Herbert Hoover could turn things around. So when the election came, voters flocked to his Democratic competitor. Franklin D. Roosevelt promised a New Deal for Americans, a comprehensive set of legislation to support struggling citizens and put the country back to work. The massive federal intervention Roosevelt proposed was a radical challenge to the individualist ideals that governed many Americans' lives. But due to the extreme circumstances, he began his presidency with public and political support. With the help of his advisors, Roosevelt's first 100 days in office were perhaps the most eventful of any U.S. president. In just over 3 months, he pushed over 15 bills through Congress and created an alphabet soup of government agencies to help farmers, workers, and businesses. The New Deal's first priority was stabilizing the banks. Over the previous 3 years, many Americans had withdrawn their savings out of fear the bank would lose their money in bad investments. So to regain the public's confidence, FDR increased federal oversight of commercial banks and created bank insurance to guarantee that any deposited funds would always be available. Next, he established the Federal Emergency Relief Administration. FERA cataloged each state's need for relief and provided funds to help citizens afford groceries, rent, clothing, coal, and other necessities. Meanwhile, the Agricultural Adjustment Administration subsidized farmers and educated them in improving planting techniques. These policies fed and housed thousands, but they didn't significantly address the New Deal's biggest promise, reducing unemployment. So the Civilian Conservation Corps was established to employ over 250,000 young men for projects like tree planting, irrigation, and fire prevention. The CCC offered on-site work camps that provided food, shelter, and education to those employed, mostly young, single men with families in need of relief. Subsequent programs like the Works Progress Administration and the Tennessee Valley Authority added projects building roads, bridges, and hydroelectric dams. The WPA also funded art, writing, and theater programs. These initiatives cut civilian unemployment in half, and they did so alongside labor acts that abolished child labor, granted unions the right to collective bargaining, and set the first national minimum wage. Benefits were also created to help those unable to work. The Social Security Act established an old age pension system in addition to unemployment insurance, disability benefits, and welfare assistance. But despite these sweeping policies, the New Deal helped some groups more than others. Black Americans were hit hardest by the economic downturn, and the New Deal's impact on Black communities varied widely. In northern cities like Chicago, Black citizens received a large share of jobs, vocational training, and education, with New Deal programs teaching more than 1 million Black Americans to read. Northern Black communities also received an influx of public housing, though it was heavily segregated. In the South, results were less positive. Roosevelt relied heavily on the support of Southern Democrats, who welcomed economic development but fought to preserve white supremacy. They ensured that new labor laws excluded domestic servants and agricultural workers, occupations held by many Black Americans. These politicians and many others also undermined Eleanor Roosevelt's attempts to push her husband toward supporting a federal anti-lynching law. As a result, the New Deal has often been called a raw deal for Black communities, and many modern inequities in housing, employment, and financial stability are partially due to New Deal programs prioritizing white Americans. In these ways and more, the New Deal didn't fully live up to its promises. Despite employing over 8 million Americans, unemployment never went lower than 14%, and the U.S. economy wouldn't fully recover until the country's mobilization for World War II. But this bold campaign of progressive policies did empower unions to start their own revolution. In the coming decades, Northern liberals, Black Americans, and other working minorities united to fight discriminatory hiring. In the process, they reshaped the Democratic Party, challenging its racist leadership and laying the groundwork for an emerging civil rights coalition.
On the poverty thing, I want to say that this is not going to solve poverty. 30 years ago, Roosevelt talked about the 1/3. Today, we're talking about the 1/5. But it is a begin. And as President Kennedy said, let us begin. And this is a beginning. And if it works, as the Peace Corps works, then we'll improve it. If it doesn't, we'll correct it. But let us begin.
I see 1/3 of a nation ill-housed, ill-clad, ill-nourished.
This war on poverty is the longest battle we have faced as a nation. Over 50 years ago, we began a new march against poverty. New leaders, new ways to fight this battle, born out of a spirit of community, of the individual. A framework to expand economic opportunity, to do much more than we had done in the past, in new ways to rebuild our neighborhoods, to create jobs and businesses, programs, yes, but also people working together, inspired people, inspiring agencies, pioneers in our communities. We pushed new frontiers. Pursuing community-driven action, embracing economic development, education, housing. Millions have risen out of poverty. Over time, we tested new ideas. As we confronted new challenges in our families, our communities, our jobs, we stay constant, driven by the values we have always shared. 50 years later, the legacy endures.